And I see Andy, and I see Mary, and I see a kitty cat, and there's, oh, hello, everybody. They hit the start button early today. I have bad news for you, and that is that this presentation will go on time, and it will take an entire hour, but it will seem a lot longer than an entire hour. Oh, somebody's calling me. Who is it? Who is it? Okay, I'm going to go answer the phone, and that mediocre presenter will be here soon. I'm looking for him now. Thank you. And I would go do something else if I were you. All right, I'm silencing my phone and starting this webinar. My name is Alan Gassman, and I went to the Heckerling 57th Institute a few weeks ago, and I learned quite a bit. So what is the Heckerling 57th Institute? It has nothing to do with Heinz 57, although they may have been co-branded, I don't know. Philip Heckerling was an amazing man who was at the University of Miami for many years and organized a number of continuing education programs. When he was at the helm of the University of Miami LLM program, which is a program that lawyers go to after they get their law degree, he came upon the idea of making this a national program. It was held for many years at the Fontainebleau. Many of you and I went to the Fontainebleau in the 1980s. Many of you went there in the 1970s. Thank you, Brittany, for the coffee, and attended this conference. It is a wonderful conference, and the history of the conference is set forth in a video that you can find on YouTube, where I interviewed Professor Jerry Hesch, who was there from the very beginning and spoke at the conference many, many years. The nice thing about the conference is that it is very well attended. So it's really a trade show and an educational conference all in one. It starts on Monday morning and it ends early Friday afternoon. And by then your brain can be fried. There are, I believe, more than 3,000 attendees, at least 150 booths in the exhibition hall, and a lot of geeky estate planning and tax people at the bar all hours. So don't get a hotel room near the bar or you will hear the buzzing of bees. So I learned a lot. All the tax lawyers in our firm went. We had a very nice time seeing all of our friends who we had last seen before COVID. This was pretty much the first Heckerling Institute, at least the first live one after COVID. And I learned so much that I can't even try to describe it all to you. So I'm just going to end the program right now. No, actually, I'm going to tell you a lot of the things I learned, and we're probably going to do a part 2 sometime. Now, if you came in through CPA.org, you're going to get 1 hour of credit. There's going to be 4 polling questions, and enjoy. If you came in through our law firm, no such luck. We're not actually good enough to get credit for lawyers or other professionals, so just bear with us. In about 2 hours, Brittany willing, you will get an email, and if you open it, someone from Nigeria will send you $2 million as soon as they get your social security number, date of birth, and Visa card number, and the wiring instructions to your account. Alternatively, you'll be able to click on it and watch the presentation again and forward this to your friends. Okay. Now, this series continues to go on, and I will tell you that one of the best things that I learned at the Heckerling Institute is that there are at least a few dozen people watching these presentations, and that there's a lot of couples watching the presentation where the one spouse is a tax professional and has no life, and then the other spouse wants to do something with them. So they watch this together, and some of them eat bagels and cream cheese and then throw them at the screen. Whatever you want to do is good for me. Next week, basic estate planning and LLC planning with Dick and Jane,
including respelling how to spell LLC. Saturday the 11th, I'm going to talk about asset protection, and then my very, very brilliant friend, Gary Moskovitz, who is a medical doctor and a wonderful thinker, is going to talk about professional acceleration strategies. He and I are both followers of Sri Kumar Rao, who you may have seen on my previous presentations. So don't miss Gary Moskovitz. I can't promise that he'll wear a coat and tie like his picture there, but he might. Also, I'm very proud to mention that Marty Shinkman and I are going to start doing something that Marty calls practical planning quarterly. So we're going to get together every 90 days or so. He's going to recognize that I exist, and then we're going to talk about his quarterly newsletter and what is in his quarterly newsletter. We just updated the IRA and pension book. It is now completely updated for Secure Act 2.0 and everything we're going to talk about here. Thanks to Bloomberg B&A for giving Marty and Jonathan and I a writing award at Heckerling, and for giving Jerry Hesh a Lifetime Achievement Award, which was extremely touching. So if you've never seen Jerry Hesh and Jonathan Blottmacher, this is what they look like. They were disguised because they had not tipped the bartender the night before. Okay, I have organized the National Institute for Charitable Education to allow law students to write about charitable issues and charitable topics in order to earn pro bono hours. So if you know any law students who want pro bono hours, they can participate in the updating and otherwise of this book on charitable giving, which is owned by the 501c3 organization, or do this yourself. My final last advertisement here is that I went to Stetson Law School on Thursday, and I met with Professor Flower, Robbie Flowers, and a number of law students to announce the Stetson University Law School Diversity and Estate Planning Fellowship. 2 students of color will be selected in the next 3 or 4 weeks. They will receive monetary awards, and they will attend and become very active in the Suncoast Estate Tax Planning Council in St. Petersburg, Florida. They will each have 2 mentors, and they will use their pro bono hours to prepare and deliver presentations on estate planning to help those in need in communities where, quite candidly, they can't afford a will, but they really can't afford not to have a will. Because you have people who die owning not a lot, but it's a lot to their family. It goes half to an ex-spouse that maybe the divorce didn't get clear. It goes into a guardianship, which costs more than what's there. No one knows who to appoint as the guardian. If we could just show people how to use pay on death accounts, show people how to use simple wills, life can be much better. So my first polling question is, would you or your estate planning council be interested in A, sponsoring a student to participate the way I'm doing and the way Marty Shinkman's doing? Oh, I'm sorry, I've got to drop the poll. Oh, good, thank you. So are you interested in A, sponsoring a student to participate, B, participating in a diversity acceleration workshop, which will be free, C, volunteering to mentor a student of color, D, the number we have dialed is out of service, or E, next question, please. But we are finding that we're finding handfuls of people who are very enthusiastic about this being a way to actually help with diversity and to help specific people who are working hard to be responsible professionals like you, maybe not so much like me. Okay, here we go, page 22. And by the way, I'll go about 8 minutes over. For most of you, that's 3/10 of a billable hour, given that I just spent 7 minutes in shameless self-promotion. Okay, the first thing about Heckerling, there were no materials this year for the first time ever, I believe. There were no notebooks, no binders, no big bag to carry around. People didn't get back pain. Everybody just, and there was not even a little slide-in thing. They just showed you how to put it on your computer, and the wireless was excellent. So the first thing I did was I called Brittany and I said, print all those materials and get someone to drive them to me. It's about 2 hours from here, my office, to the World Marriott. So I ended up with the materials Monday night and I used them. Next year, I'll just print them before I go because I don't like trees. I like to mark up documents. Number two, be forewarned, the Airport Marriott rooms with the special pricing ran out, I think, the day of the announcement. So what happened to us was Riley, my assistant, clicked on the Heckerling get your room deal here and went straight to that took her to the Marriott webpage, and she booked our 5 rooms, and it cost, I believe, about $200 a day per room more than what the Heckerling deal was. So when we got there, I said, can I speak to the manager about this? And they said, no, thanks for being an Envoy member, but our manager will not speak to you about this. And you have 2 choices. You can leave the premises, or you can give us your credit card and pay this extra $800 per person. I believe that's what it was. So that was fun, and I'm looking forward to meeting them at our American Express event. And if anyone else had that problem, please let me know, and I will represent you for free. Number 3, the presentation video was on channel 170 in the room for the primary room, and it was excellent. A lot of people didn't realize it was on channel 170, but there it was, so you didn't have to go down into the conference area. Number 4, and I was so pleased with this, just so you know, these little computers that you would now buy for $3,000 or $4,000 are the size of my hand, you know, much smaller than my ego. And those now come with an antenna if you want, or you pay them an extra $80, you have an antenna, and it will work on wireless. So I was able to bring two of my normal computer screens, my normal printer, my normal keyboard, and then I used the Marriott's wireless. It was excellent 95% of the time. So I was able to, you know, be productive, which we like to do. Number 5, as always, you will not find a restaurant with a single seat that week at the Marriott World, but I was pleased that Ubers were very, very available, and there were a lot of really good restaurants near Heckerling, 5 to 7 minutes away by Uber, and that the Uber drivers were excellent. So on to less important things. Treasury Secretary Yellen had remarks that were covered in Heckerling on what they're going to do with some of this extra IRS money. Did you know that only 10 to 15% of phone calls to the IRS were answered last year? This year, she is predicting an 85% level of service with 5,000 additional customer service representatives. They'll probably be wrong a high percentage of the time, but it'll be nice to talk to somebody. Secondly, they are automating the scanning of millions of income tax returns, which will make for faster refunds, thank heaven. And then they're hiring the private industry to come in and help them get mechanized. So we have something to look forward to. It's not only to put auditors in the field to criticize your work, it's also to help services, etc. There is also information the IRS will no longer retain estate tax returns beyond 75 years. That really shocked me. I don't know about you, but I've never asked for an estate tax return going back to 1945. But if you need one, you better ask soon, because they're going to be throwing those away, but they will be enhancing their record keeping. And you can file a Form 4506 to request a copy of a tax return, and they're going to have a 40-year deadline on the Form 4506, just so you know. Now, this is a very touchy topic. Secretary Yellen was questioned June 8th, 2022, about can people set up an irrevocable trust that is outside of their estate for estate tax purposes, yet on death get a new fair market value income tax basis. Now, I've discussed this at least 25 times on these webinars, And Secretary Yellen simply said, hey, we're working on it. We're working on it very hard. It will be very soon. Well, I guess the definition of soon is more than 7 months. But I was a little bit disheartened, and so were some of my colleagues, by a discussion in the developments committee where in the recent developments, the presenters were excellent. But one presenter was very, very sure and very, very adamant that there is no step up in basis. And I believe and have been taught by some very, very good tax lawyers that the possibility of a step up in basis is at least 50%. It's just as strong as the possibility of there being no step up in basis. That comes from Howard Zaritsky. He's a very conservative guy. But another panelist said that those who believe there's a step up are flat earthers, which I really, I just don't believe that this is happening, because what's happening is people are dying. Instead of the step up, the CPAs are taking the safe position that there's no step up, and then I believe the family will sue them later for malpractice. So there are prepare penalty issues, and if you want to do the best thing for your client, please don't blindly follow the majority, because the majority may be wrong. Okay, now this is another very exciting piece of news, which is why I put it in lavender, and that is that I remember I had Professor Moorhead at the University of Florida in 1982, and he was a wonderful professor, and he taught us about the Administrative Procedures Act. And I still remember from that before a governmental agency can promulgate a regulation that changes the law, because the agency is making what's called a legislative rule, they have to give the public notice in advance of the rule. They have to get comments from the public. They need to consider all the comments. And then when they issue the rule, they need to discuss the comments. Well, the IRS over the past 75 years, or whenever this APA was passed, maybe it's 40 years, has not done that in issuing notices. And many of these notices are anti-taxpayer. So, son of a gun, in 2022, somebody wakes up and in litigating the conservation easement rules and some IRS rules that you have to jump through this hoop and that hoop, bending upside down and touching your toes in order to write off a conservation easement, 2 different appellate courts have said those rules don't apply. The IRS never put this out to the public, or even if they did not respond to the public's comments. So Professor Donaldson said that maybe the ERC, the PPP time wage credit, which was interpreted by the IRS to not apply to relatives of majority owners, maybe under this act, you can get the ERC credit for your relatives. So our law clerks have spent dozens of hours looking at this issue, and the answer is probably not. It probably does not invalidate the ERC notice, but you can take your own look at this and ask for a second opinion as to whether Notice 2021-49, which indicated that you cannot take the credit for family members, is invalid. Because now the credit for family members comes from another law that is specifically referred to in the CARES Act. And then this is confirmed by the notice, but the notice at the same time requires everyone to file an amended return, which we believe is legislative. And if that's legislative, does the entire notice fail? And if the notice fails, then does the relative rule fail? And the answer is, I don't know. I'm still looking at it. Okay, on to the next polling question. This is a special gift for all the people who always say, where's the third polling question? Where's the fourth polling question? Who is Matt Poling? Okay. If you're interested in a free study group on the $50,000 IRA transfer to charitable remainder trusts and private annuities, this will be a private study group. We will have Jerry Hesh and Ed Morrow there, and the three of us will talk about how to use this nice little loophole that was just invented and may be quite wonderful or maybe not worth the effort. But if you are interested in participating in this study group, and if you agree to participate, there will be no continuing education credit, and you will have to give us a little tiny commentary on some part of this rule so that we can go over it during the study group. We will also be serving Mogan Dave and wine. So the answer, A, are you interested? Yes. B, no. Please call again at your convenience. Or D, I gave at the office. Page 36, it was pointed out at Heckerling, interest rates are going up. My gosh, I did installment sales in February 2022, and I could use 1.9% because you can go back 2 months. Now I do an installment sale next month. I've got to use the lower of 4.34%, 3.84%, or 3.86%. A lot more leakage coming back, but still people are doing the installment sales. It's still a lot better than when I started doing installment sales in the 90s when the interest rates were much higher than that. But please get these installment sales done sooner rather than later, generally as soon as you can. Now, I usually don't stay over on Friday at Heckerling. I usually go stir crazy and leave Thursday, but I wanted to hear Natalie Choate's 90-minute talk on Secure Act 2.0 and the interpretation of the rules on how to have an IRA payable to a trust. And if you ever want to hear a perfect speaker with perfect humor and wonderful content, then definitely go ahead and listen to this tape if you can get hold of it. It was wonderful. But the most important thing about her talk was I came back and I talked to my partners, Christopher Denicolo and Brandon Ketron, who co-authored the IRA trust book that we write. And I said, did Natalie say anything that we didn't know? Is anything changed since the last time our book came out? And Ken and Chris and Brandon both agreed. Thank heaven, there's nothing new yet. Secure Act 2.0 makes good sense. I'll cover some of that. And Natalie's materials are now up to date. Her outline is beautiful, as is she. Now, Secure Act 2.0, the main change for most people is going to be, instead of having to take your minimum distributions at age 72, if you were born in 51 or later, then your minimum distribution age is 73. If you were born in 59 or later, our minimum distribution age is 75. If you were born in 50 or earlier, then your minimum distribution age is 72. So here's a chart. I was going to write a poem and a song, but I just didn't have time. But here's a spreadsheet, and I'll be glad to send this spreadsheet to anyone who would like to have it. But here's someone with an IRA of $1 million, and they are 70, and they have to start taking money out at 72 because they were born before the year I gave you, a 6% rate of return. And here's the amounts that come out. Now, when I do estate planning now, we do a chart for every client, as many of you know. And Lauren goes ahead and puts this chart on the client's chart so we can get an idea of what their cash flow is expected to be from the pension plan. And look, at age 92, they still have $1.1 million in the plan. Even at age 95, they have $1 million in the plan. So taking the IRA out over the life expectancy of the owner of the IRA, this is why IRA rollovers are so popular, like the song "Roll Me Over in the Clover, Roll Me Over, Lay Me Down and Do It Again," which is a great song. Now, in addition, we said, well, what if you were 75 and you don't have to take your distribution until age 75. And so you would take a zero distribution in years 1 through 5. Now it's built up to $1,338,000, and you've saved this much in income taxes. So you've saved a total of about 140 in income taxes. But then, and by the way, this cumulative column is wrong. I've got to fix it later. But then you take out more coming out in later years. So eventually it catches up with you. But until it catches up with you, this is nice for 75-year-olds. And they mentioned at Heckerling, why did it stop at 75? And that's because the budget committee said you can only afford to get this to age 75. If you want it past age 75, you're going to have to take away something else from the taxpayers, because Secure Act 2.0 not only was passed in a bipartisan matter, but it's also balanced in the budget. So as Natalie Choate said, she goes, my husband finally said, well, you know, that Biden's not such a bad guy after all. I don't have to take my distribution until I'm 75. So I'm glad that people are happy. Now, page 42, just get a chuckle. I haven't had a chance to review this. A couple of very bright law clerks have been writing it, but a big change in the Secure Act 2.0 is the ability to put up to $200,000 of your IRA into a qualified longevity annuity contract, also known as a quack quack. So if you that would be if both spouses do it, it's two clacks, a quack quack. And anyway, what happens is I can take, it used to be the greater of about 150,000 or 25% of your IRA. But now if I have 200,000 in my IRA, I can buy a clack and not take any minimum distributions, and the clack starts paying me an annual payment for my lifetime, which doesn't have to start until 85. So you put $200,000 in a clack, and let's look at some numbers here. We ran some numbers, and it's interesting how the numbers came out. This person is born in 1959. He's very old and feeble, obviously, and he puts $100,000 into a clack. And look at this, he gets a life income of $41,000 a year for the rest of his life, beginning at age 85. Now, of course, you're saying, what if he dies before page 85? Well, then the life insurance company has a party. But the nice thing is he never had to take a minimum distribution. And if he is fortunate enough to live to age 100, he will have received $661,000. So these are very interesting instruments. The other thing that the new law does is it says that the clack payments can increase by up to 5% a year. So and by the way, you don't have to use age 85. You could use age 80, then the payments will be smaller, but they could still go up by 5% a year, which means the first payment would be lower. Here's another interesting thing. We went on the internet, even though our mothers told us not to, and we put in for this person who wanted a clack, and this carrier said they would give $41,000 a year. This carrier said $33,000 a year, and this carrier said $29,000 a year. So you know what? My dad always told me it pays to shop around, except for lawyers and CPAs. That is the clack. You're going to have a lot of people in the annuity business pursuing the sale of clacks. The new law applies immediately, but of course the life insurance companies are all trying to figure out how they work. It's not clear to me whether you can do an equity index policy in a clack, so everybody's going to want to be very careful. The one-time election to transfer $50,000 from your IRA to a charitable remainder unit trust or to buy a charitable gift annuity really got my attention, because it's a wonderful way for donors who really can't afford just to give IRA monies directly to charity. They don't want to afford it, or they can't afford it, but they would like to help charity, and they would also like to defer income tax. So let's say that somebody's minimum distributions are $50,000 a year, and they're married to somebody who also has a $50,000 a year minimum distribution. They're both over age 71. So this qualified IRA distribution rule can apply. So what can they do? They move 50 each, a total of 100 for a married couple, and they move it either to a charitable remainder trust, which could provide that 90% of the value will generate a joint and survivor payment to them, with the remainder going to charity, which could be their family foundation. So they will save this year $37,000 of federal income tax. They may save some Medicare tax, and they may save some state tax, and then they'll get those payments over their lifetime when they may be in a lower tax bracket. So here's one that I was working on this morning with Dakota, our law clerk, and he's north of here, so we call him North Dakota. And on page 53, actually I should have started, here's page 52. Now, one idea is we went to the Humane Society website and put in a 73-year-old couple, they're both 73, and they put in 100,000, and they can get 5,600 a year for the rest of their life for their 100,000. That's a 5.6% rate of return. And the Humane Society basically says, we're going to put 40,000 in our pocket and reserve 60,000 to give you this benefit. So the clients are going to get recognition from the Humane Society. They're going to save $37,000 of income taxes, and that's a nice thing. And here's what, if you do nothing, you take out the 100. Let's say you live in a state where there's a 6% income tax. 43,000 comes into the income tax. You're left with 57,000. That's going to grow at 6% interest, and in 20 years you have 172,000. Well, here's another alternative. Call me at the Sarah Gassman Foundation, where we teach needy students piano lessons, and let's say these piano lessons are going to go up in cost. They're going to cost $25 a lesson. So you transfer $100,000 to our foundation or any other foundation, and I am going to go to the Schwab website and immediately buy a life annuity on these two 73-year-olds. It's going to cost me $85,000, and I'm going to spend $15,000 on piano lessons. Schwab is going to pay me $6,923 a year, which I'm going to deposit into the Sarah Gassman Music Foundation and immediately pay the clients. And then I'll personally guarantee the payment. So the charity gets $15,000, and that pays for how many piano lessons? That will pay for 600 piano lessons, one-on-one, by a caring piano teacher on the bench with a disadvantaged child. And what happens for the clients, or the donors? They get $6,900 a year, and let's say that they do this just before they move to Florida. They move to Florida, they stop working, now they're in the 20% income tax bracket, and after taxes, once they get to the 17th year, they come out ahead, not behind, assuming a 6% rate of return. If they live to 20 years, one of them lives to 93, whether they want to or not, then they're $14,000 ahead and 800 piano lessons ahead. So think about this for your charity. The rule of thumb is closer to what the Humane Society does. I love their website where you can just hit these numbers so fast. But the charities don't have to keep 40%. They don't have to keep 50%. Many charities will be glad to get 15% if they can go ahead and insure the risk of payment by buying an annuity elsewhere. So we have lots of pages on this, including what the printouts from the Humane Society show, et cetera, et cetera. And now to, I believe, our fourth polling question. Is it the fourth one, Brittany? No, it's the third. I can't count, but that's how the time slips work too. All right, I will read it to you. When are the following upcoming conferences? The first one that I helped found in 1998, the 25th anniversary of the one-day Johns Hopkins All Children's Annual Estate Planning Seminar. starring Jerry Hesh and many others. Your donation to this program gets you a full day of CPE that you can watch anytime you want. Then in May, Jerry Hesh and I and Jonathan Blottmacher are going to be in Dayton, Ohio. I'm going to go see the Wright Brothers Museum and the Air Force Museum the day before or the day after. And we're going to give the Heckerling Health Foundation conference for Rick Fee. Heckerling Health, Mr. Kettering invented a lot of important stuff. He had donated to Sloan Kettering Hospital, and also he founded the Kettering Hospital System in Dayton. Please make that a date with us. Then Jerry Hesh's Notre Dame Institute will be September 20, 21, and 22 in South Bend, Indiana. And then next year's Heckerling Institute will be at the World Marriott. Get your rooms as soon as you can, and that will be in a date to be announced in 2024, or you could put E, all of the above. Okay, page 68, more of crats and cruts and stuff like that. Now we go to the Treasury Department's Green Book proposal, and this is the proposal that the Biden administration put out many months ago. It doesn't really mean anything now. Until the Democrats could capture the Senate, none of this is going to happen. But they just note that if you have a private foundation and you have to make minimum annual distributions, you could just make them to your Schwab or Vanguard or whatever donor advised fund, or your community foundation, and then just sit on them forever. So people who are concerned about the minimum 5% distribution for a private foundation, you don't need to worry. Read Dale Carnegie's book, How to Stop Worrying and Start Living, or just send a check to your own donor advised fund until this legislation would ever be passed. Now, we are in 2023. Let's say that you had a client who died after their required beginning date on the IRAs. They were 73 years old, they've already died, and the 10-year rule applies. Their children don't have to take a distribution for 10 years, but wait, the proposed regulations said that you have to continue taking you have to take minimum distributions as if the deceased plan participant was still living. The IRS Notice 2022-53 forgave that for 2021 and 2022, but did not forgive it for 2023. Until we get regulations, we're not going to know whether there will be a minimum distribution for people in that category in 2023. And here's what they said at Heckerling about this issue. Nothing. It wasn't mentioned. So just wanted to let you know. All right. Now, there is a naked bear. And if you've ever been to Alaska, you've probably seen a lot of them. They are absolutely shameless. They never get dressed. But they have an issue coming up, and that is the Corporate Transparency Act. There was a very good 1-hour presentation or 50-minute presentation on the Corporate Transparency Act. And let me give you the down and dirty. This may again begin to apply in 2024. I personally think it'll be pushed back. I think lobbyists for everybody will be saying, push this back. But in 2024, you may need to make sure that every LLC, every corporation, every limited liability company, every entity that files for a state charter will have to put together a short disclosure. The form should be pretty simple because they're forecasting that it will only cost $85 for the average business owner or company owner to fill it out. What will it say? It will say, here's the company name. Here is the person or people who actually own more than 25% directly or indirectly. So there's not going to be any hiding. Here is who formed it. Here is the person who works for who formed it, who actually formed it, and here's what the entity is, and here's a driver's license number or a passport number or a social security number for those owners. So it should be pretty simple. Everyone's moaning and groaning. You know what the government's going to do with this information. They're going to send it to a room somewhere and probably never be able to use it. But those Panama Papers showed a lot of crime using unknown LLCs in South Dakota, as a matter of fact. So this is just going to be another piece of paper. And when the act takes effect, you'll have to put this piece of paper, file it within a few days of opening the entity. So it'll just be another service that your law firm or your CPA firm will provide. And yes, Big Brother is out there. The effective date, January 1, 2024. But companies created or registered before January 1, 2024 will have until at least December 31st, 2024 to get this filed. And if you don't want to do this for your clients, let me know. I'll be glad to do it for your clients. We'll find people and we'll teach them how to do this. Now, the biggest substantive surprise for me at Heckerling had to do with Firehouse subs. Now, I don't know about you, but I thought that Firehouse subs were, because they were really hot, they got your mouth hot because of all of the peppers. But actually, the Sorensen brothers grew up in a family of firefighters. Their father was a fire captain at the firehouse, I believe, in the Jacksonville area, or at least they were in Jacksonville. Chris and Robin. Chris was a rock and roll musician. Robin and Chris opened up a sandwich shop. And this is a lovely story. And this picture here is of Robin, Chris, and an IRS agent. Actually, I don't know who's in the middle there, but there's Robin, there's Chris. So they opened up this restaurant in 1994, and they opened up a company, an S corporation, in 1995. And by 2011, they had 500 Firehouse restaurants. 90% were franchises, and they were grossing over $550 million in revenue. We don't know what their net income was. So what they did, and I'll get to the charts, and we still need to improve these charts, but we worked on them quite a bit. So in 2014, Robin had a revocable trust, and he owned 35.56%. Chris owned 35.56%, and other owners had 28.88%. So they decided to put $5 million each worth of stock into irrevocable trusts for their descendants. So Robin set up what's called a family trust. I would have called that a dynasty trust, so I could have charged more for it. And Chris called his a family trust. And they transferred 10.43% ownership approximately from each of them to the family trust. And they called that a $5 million gift. And they filed a gift tax return. And the gift tax return said, I have given $5 million worth of stock. And what I gave was the number of shares of stock that together constitute $5 million of value when I made this gift in December of 2014. Now, they don't tell us what they valued the company at, but let's see, 5 million times 10, because of 10%, would be 50 million. And if they took a 1/3 discount, they were valuing the company at about 75 million. So that was nice. And they used what's called a Wandry clause. They didn't say, I'm giving this many shares. They said, I'm giving a number of shares equal in value to $5 million. And the Wandry clause they used, I thought, looks pretty good. And then about 8 months later, they went ahead and they did an installment sale. And they decided, I don't want to own 25%. I want to get down to 17% and get that family trust down to 17%. So 8 months later, without a new appraisal and without any sort of Wandry clause, they simply exchanged shares for a note. And afterwards, they were at 19% each. The family trust was at 16% each. I have not closely proofread these charts. The law students put them together. They look right to me. They did not file a gift tax return for 2015. The note agreement that they signed did not say, hey, if these shares are found to be worth more than $2,858,000, then we will owe more to the living trust. They didn't do that, and they didn't use a Wandry clause. So what do you think the IRS said? Well, of course. Oh, and then what happened after that? This is lovely. Later on in 2021, the company sold for $1 billion. And $1 billion, $153 million went into Robin's family trust, and $153 million went to Chris's family trust. And I hope that Chris and Robin paid the income tax because the trust was defective for grantor trust purposes, I hope. And therefore, the majority of the money went to the family trust to avoid estate tax, which is a great, great cause. Well, the IRS audited this. And, oh, and by the way, why do people sell for $1 billion? And the reason is they wait until it gets to $1 billion and then they sell. It's a psychological threshold. A lot of sales that we've seen and some that we've worked on are at exactly $1 billion. As soon as they get to $1 billion, boom, they are out of there. That's a lot of peppers on those sandwiches, by the way. So we don't know everything about this case, but we know a lot about the case because it became tax court litigation. And the IRS went for penalties and interest, and the matter settled. But I think what's important is the IRS came in and said, okay, this was really 11 million that you put in, not 5 million. So you've got a tax on 6 million. 6 million times 40%. 6 million times 40% is 2,000,004. Give us 2,000,004 in taxes. I think that's what they did. I'm not absolutely sure. Well, these guys ended up with 153 million going to these dynasty trusts. Do you think they would have even cared if they paid 10 or 15 million dollars of taxes, penalties, and interest? But one thing that we all need to be forewarned about is that the service is using the cow analogy. Now, I think this is utter nonsense. But what is the cow analogy? The IRS says, let's say that instead of stock, they gave cows. And let's say they transferred 7 cows and they transferred 7, they only should have transferred 5. And let's say that by the time we audit them, they've already slaughtered 3 of the cows and sold them as barbecue. So then we can't get the 5th cow back. Is that the silliest argument you ever heard? Has the IRS never heard of economic adjustment? Or is the moral of the story to make sure you keep at least 5 of the cows there in case the IRS comes back? But anyway, that is what the IRS is doing. The bigger news is that the IRS is not accepting Wandry clauses. They are apparently challenging Wandry clauses, but they did settle this case. We don't know what the settlement was. The safer clause that we sometimes use is twofold. Number one, you provide that 99% of what I'm transferring is going to the dynasty trust. 1% of what I'm transferring is going to a public foundation, the community foundation, who will do what I ask them to do on the charitable side. And if it's actually 7 cows instead of 5 cows, the 2 extra cows, or the money I derive from the sale of the 2 extra cows, after the expense of buying barbecue sauce and sharpening my knives, will go to the foundation. Well, now that clause is not against public policy because a charity gets something out of it. So you're much stronger, and you've got the appellate cases of Petter and Christensen. The other thing we do that this taxpayer didn't do is when we do a sale, we use a Wandry clause and also say that if the Wandry clause is for any reason disregarded or disrespected, then the sales price goes up. And if you think about it, can you imagine if these people had won on the Wandry clause working, and therefore less than $153 million worth of stock had gone in there to save $6 million of gift tax? Maybe it's better to use the Proctor clause, which is, or the King clause rather, which is, I'll put this in. If it turns out to be more, then you owe me more back. And maybe you say, and 5% of what you owe me back will go to charity. But we all need to think about these Wandry clauses. But look, the aggressive planning saved this family a lot of assets. Okay, page 114. And like I said at the beginning, for those of you who were paying no attention at all, I'm going to go at least 8 minutes after the hour. So for those of you who are not mathematicians, that'll take us to 12:08 Eastern Standard Time. For those of you in California, that's 9:08 Pacific Time, to be specific. And then I'll answer some questions, the ones that I know the answers to. And then we'll do a Heckerling part 2 sometime. Page 114, Donahue v. Smith. If you have publicly traded stock and you're putting it in a GRAT, that is not a mere change of form as far as your registration under Section 16B of the Securities Exchange Commission, which I know nothing about whatsoever. Rost v. the United States. This is an interesting case where a Stiftung, a lot of you I know have Stiftungs, but a Stiftung is a European entity that is very much like a trust, but also very much like a partnership, because you put the assets in the Stiftung and it's for the benefit of stated individuals and or charities and or entities, and the foundation manager then can allocate the assets in the Stiftung in their discretion with no obligation to make a distribution to any one or more people. So, you know, if me and my brothers my brothers and I put $1 million each into an LLC, we each get a third out. But what if we gave you the authority to decide what I get, what my other brother gets, what my other brother gets? If you get a judgment against me, there's nothing to grab onto because I don't have the right to anything in particular. And Wyoming and New Hampshire have foundation statutes. Panama has foundations. Bahamas have foundations, and Liechtenstein, which is very now becoming a more and more popular jurisdiction, have these Stiftungen, which are similar to a foundation. Well, this taxpayer was apparently told you don't have to file any foreign disclosure, so don't worry about it. Just put it on your income tax return. Now, if this had been properly drafted, I believe, I'm not 100% sure, I'm going to look into this, it could have been taxed as a partnership. But instead, the terminology in the agreement made it look like it was a trust. So UBS reaches out to the owner in 2010 and says, we're going to tell the IRS about you. You better go file the right tax returns. And sure enough, right away in 2013, they file the returns. Does it surprise you that there were sizable penalties? So I've also given you page 120 of the Gassman and Markham on Florida and federal asset protection law on foundations, and we'll be rewriting this to take this case into account. And I'll be talking to Alexander Bovey from Massachusetts in Boston about not only his blonde wig, but also how this is going to work. Sanderby, the commissioner, if you're going to have litigation with the IRS, You've got to have a personal representative appointed under the estate. You can't do it in the name of a revocable trust. The Kiefer case, page 131, Mr. Kiefer had a partnership interest, and just before the partnership interest was sold, he transferred it to a 501c3 charity to get a charitable income tax deduction. But he didn't transfer the whole partnership interest. He transferred that portion of the partnership and my rights associated therewith, which corresponds to what's being sold next Wednesday. And the IRS said, nope. They applied the assignment of income doctrine and said, if you're going to assign ownership to something before the sale, that's okay. But you've got to assign the whole thing. You can't say, I hereby assign the milk in the udders of this cow that is being transferred with a wandry clause. You would have to transfer the whole cow, the whole kit and caboodle. If you have 3 kits and caboodles, you could transfer one of them, but you got to transfer the whole one, not a third of a kit and caboodle. I think I've confused everybody if you were listening. There's a very good article on this by Richard Fox and Jonathan Blotmacher. The other part of this case is the 99th reminder that when you give anything to a charity, the charity must give you a written notice that, number one, we received it. Number two, you received nothing in value back. And if that is not done in writing contemporaneously with the donation, then you don't get any deduction. And in the Kiefer case, they told him something before he made the donation, then they told him something after he made the donation, but those 2 documents were not one document, and so he lost. Now, the good news is you don't need the contemporaneous notice, thank heaven, until just before the tax return is due. So if you're in a charity and you received a donation in 2021 and you have not yet given a contemporaneous notice that meets all of the rules, you may only have until April 15th to give that notice, or not. If you don't give the notice, then the client may completely lose their charitable deduction and their love for you as a tax advisor. Page 41, the farmers read a magazine article that apparently said if you put crops in a charitable remainder annuity trust, and then the charitable remainder annuity trust sells the crops and buys an annuity contract, which then pays you money over time, then you'll basically pay almost no tax any time on the sale of the crops, and only pay tax on the income aspect of the annuity. Well, the good news is the tax court allowed them to pay no income tax at the time of the sale, but did force them to pay income tax on the sale income over the time of the payments that they received, coming out worst first. So this is a really nice planning opportunity if your clients can transfer appreciated inventory that has very little basis, and especially for farmers because they can expense it, and then let that charitable trust sell, and then take the money out 17 or 18 years later using a flip NIMCRUT. That does have legs. Now, there's no discussion there of whether there was a step transaction or whether the CRUT would have had to have been involved in the business as a dealer, but certainly bad news for some people become good news for others. And of course, don't believe everything you read in a magazine. Now, speaking of S corporations, you have IRS Revenue Procedure 2022-19, which came out, and it says that when you muck up an S corporation and you tell the IRS about it to get relief from being punished under Section 1362F. You no longer have to pay $23,000 for a private letter ruling if it has to do with agreements and arrangements that had no principal purpose of circumventing the class of stock requirement, or governing provisions that provide for identical distribution, missing shareholder consents, errors with respect to the permitted year, missing officer signatures, inadvertent errors. You just don't have to pay that $23,000 fee. And with a RevProc, you file usually a form that is just immediately accepted. So we have a situation right now in our office where a lawyer apparently didn't know about the second class of stock rules, so he had a client sell a percentage of his S corporation to somebody else, and then there was a capital account provision in that agreement that if one of them put more money in than the other, it went to their capital account as opposed to being a loan. So now I can check and see whether we can file under this revenue procedure or whether we need to get a private letter ruling. When you work with LLC operating agreements, please read them and don't let the client go to LegalZoom or don't let the client go to a CPA firm to draft the operating agreement, because quite often they are absolutely wrong and you lose your S election and then all your income gets double taxed. That's a bad thing. Okay. Takeaways on charitable gift contracting. Recently, a client agreed to give a large donation to have a building named for her in Arkansas. So they sent us a charitable gift agreement, and I could not. Oh, fourth polling's question, slide 98. Let me go there. Sorry about that, everybody. All right. Would you like to see a Heckerling Part 2 on CPA Academy? A, yes. B, no. C, I'm sorry. What was the question? Or if you answer D, I'll give you a free book of my choice. Good? All right. So where was I before doing the right thing interrupted me? Okay, what I'm going to say is when you give a donation for your client, and then building is going to be named for your client, or a school in the name of your client is going to be opened, or some sort of charitable thing is going to happen. Finally, we have a guidebook on these contracts. It was a wonderful presentation and also a very interesting presentation. And the main thing I wanted to tell you is it is there, and 49 states have adopted the Uniform Prudent Management of Institutional Funds Act, which says that when you give a scholarship fund of $200,000 to fund a scholarship at the university of your choice, that university has the ability to pull out a certain amount every year as management fees and has to follow certain procedures. So in a charitable gift agreement, you may want to ask for certain things such as, well, what if the school closes down? Well, can I have my money back? What if the school moves? Can the next building at the school be named after me? What if you're representing the charitable organization and the donor turns out to be a very famous felon later on? Can you unname the building at that point in time and maybe give them back a prorated part of their donation? If the university or the charity violates the agreement, does anyone have standing to complain that it wasn't done right? I mean, I named a building. What's that worth if they don't put my name on it? Am I going to be able to show a jury that there were actual economic damages? So there are a lot of issues. And finally, there's a good guidebook. Quite frankly, I have 2 law students writing for pro bono credit who are going through these materials will add a chapter to our charitable giving book that I hope you'll consider buying when it goes for sale eventually. And or actually, it is on sale in the Limeberg system. I forgot. But anyway, we're going to add a chapter to the book on that. And if anything you have that you would like to contribute to our book, please send it. It could be a client explanation letter, an illustration, a good idea, anything like that. Now, I think for a lot of attendees at Heckerling, the most useful and popular talk was by Turney Berry on how to handle the middle rich. And it was interesting that the top 1% of value for US taxpayers, according to Forbes, is 11 million won. So these people, I think, are pretty wealthy at 11 million won, yet they're not subject to estate tax. Not yet, or they don't think they're subject to estate tax. So for these clients, the priorities are a little bit different, maybe, than a client who is in the 20, 30, or $50 million bracket or net worth. So Turney gave a very good presentation, and then there was a very good workshop with a couple of his colleagues on what's important, what you discuss with what he calls the middle rich client. And I was glad to hear that Turney has the same issues that the rest of us have. Number one, talk to the client. Who is my client? Who's going to get mad at me at the end of this? I should warn that they should get a separate lawyer. Whose confidences are going to be given to who else? What does the client want me to do? I walk away from the meeting thinking it's one thing. The client thinks it's another thing. Write the client a letter telling them what you're doing, especially if that is a risk, and that's almost always a risk. Number three, help the client understand that this can be expensive. It takes time to do. If they are an electrical engineer or an actuary, it takes even a lot longer to do. So make sure that they understand we're not trying to be greedy. We're just trying to be thorough. And it's a big challenge for new attorneys, or what they call young people in the profession, we get browbeat. You know, you see 5 clients and 3 of them say, well, whatever you charge me sounds fair. And then clients 4 and 5 say, well, I saw in the newspaper that I should get this estate plan for $750. So suddenly the young lawyer thinks, I got to do all these estate plans for $750. 5 times $750 is about $3,700. That's a lot of work for not a lot of money. That's not fair to clients A, B, and C. Clients A, B, and C didn't say it had to be done for $750. They said, give me the right estate plan. I'll pay you the right amount. So I'm going to say now, a lot of you on this program are the clients. And as soon as a client says, well, I don't want to pay very much, I need to get the cost down, my mind goes from what's right for the client to how do I shortcut this thing? And even though a lot of us in our firm, we're all hourly, we like to think that what we do is what's needed, but it's just a challenge. And I was glad to see Turney specifically talk about it. And then he mentioned, you know, our clients are all over the country. Are your powers of attorney going to work all over the country? And his materials go on, really good stuff. And I'll finish at 172 with upstream planning. Turney mentioned it, other speakers mentioned it, and just don't forget, you know, you're meeting with Mr. and Mrs. Jones. They're in their 60s, and they have a lot of appreciated assets. And then they mention, and I got to go visit my mother in the nursing home tomorrow. And you say, well, what's your mother's net worth? $1 million. Well, would your mother like to have a power of appointment over $11,910,000 worth of your assets to get you a fair market value income tax basis on her death? let's just not forget to do that. It does work. Mikey tried it and it tasted great. So the materials have discussion of that. And I think Turney calls it upstream planning. Ed Morrow has wonderful materials on it. He calls it the obit. So I think he's making fun of the obituary. But in any event, let me go ahead now and see if there are any questions to answer. Okay. April says, at Deloitte, we were taught statutory versus legislative being based on whether the code indicated the regulation was to be under the purview of the Treasury. Well, the code may say the Treasury is requested to interpret this regulation, or the legislation may say the Treasury has the authority to promulgate regulations consistent with this statute. So it may vary, but thank you very much for that comment. Okay, can the $50,000 charitable remainder trust be stock or must it be cash? It has to come out of the IRA. So it doesn't matter. You could move 50,000 from an IRA to the charitable remainder trust. And that brings to mind, maybe you have a hard to value asset in the IRA that you move to the charitable remainder trust. That's interesting. I hadn't thought about that. Thank you, Sandra. Okay, can I comment a little more on the step-up basis on the irrevocable plans? If one wants to claim step-up, how would you recommend a beneficiary to do it? Well, I guess the beneficiary needs to confer with qualified tax advisors. And I'll say this, maybe only do it by talking on the phone until you find the advisor you want to use, because it may not be under the attorney-client privilege. When you talk to your CPA and when you email with your CPA, if your CPA prepares the return, there's no privilege, I don't believe. So you don't want a bunch of emails with your CPA talking about whether there's a step up. You find a law firm or maybe a CPA firm that's not going to prepare the tax return, and then probably it's best find a law firm that believes there's no step up. There's a lot of those. Find a law firm who believes there is a step up. There's a lot fewer of us or them, and then make an educated decision. There probably is a penalty and interest risk, although I don't think there's a penalty and interest risk. Even Treasury Secretary Yellen doesn't know what the answer is. The IRS doesn't seem to know what the answer is because they issued a private letter ruling on a foreign matter that said there was a step up. Professor Gans teaches at Hofstra, one of the smartest people in the United States. So that is my further discussion on that. Okay, Julie, can we upload the Excel spreadsheet? Absolutely. We will definitely do that. Okay. Steve also wanted to know about the step up on the irrevocable trust. The reason for it is that the code under section 1014 says if you die owning something, you get a step up. And then the defective grantor trust rules say if you have a trust and you retain certain rights, then it's considered as owned by you for income tax purposes. So if you die, do you own the assets in the trust or not for 1014 purposes? And the answer is wait and see. Okay. What does that mean that only 80% of the people get credit for attending? I don't know if I said 80%, but if you came in through CPA Academy and you're a CPA or an enrolled agent, you're going to get the credit. If you came in through our law firm, you're not going to get the credit. Okay. Does the Corporate Transparency Act applies to partnerships and S-corps? Not general partnerships, I don't think, that are not filed with the state, but with LLCs and S corporations, definitely, they will have to be filed. Yes, the government already knows through the K-1, but this is a different department than the IRS. William, you say this is the goofiest presentation I've ever witnessed. I'm glad to hear that this is the first time you've ever seen my presentation. Okay. D Graduated from Johns Hopkins. Add an S to the end of it. Brittany, add an S to the end of Johns Hopkins. I thought there was only one of them. I didn't know that there were several of them. Okay. Let me see if there's anything else here. IRS recently said my client's durable power of attorney needed to be complete and file Form 2848 if she wanted me to speak to them. Yes. A durable power of attorney under state law allows you to speak to almost everybody, but not the IRS. The IRS needs a Form 2848. Now, I'm not sure what happens when a client is incapacitated and there's no guardian appointed. I don't remember. Brittany, if you will remind me, we'll look that up and let everyone know, because it's a question that I have, and I have to answer my own questions last. Okay. Heckerling contributed to Sloan Heckerling because Sloan, who was the head of General Motors, didn't think he was well enough known to generate giving from others. Thank you for that information, Jay. I will think about that the next time I drive my Tesla. It's actually my wife's Tesla. She didn't let me get one. The better cars always go to her. All right. Brittany's laughing because she knows that's true. David, selling the crops when you receive each annual payment, wouldn't that also be subject to self-employment tax, not just income tax? I don't think so, because if the crops, you put the crops in the charitable remainder trust, then the charitable remainder trust sells the crops, gets the money, no tax paid yet, then the charitable remainder trust, when it finally makes payments out or to the lifetime payee, then that money comes out over time. Okay, Loretta, who I am forever grateful for fixing one of my spreadsheets. Secure Act 2.1, in the case of an individual who attains age 72 after 2022 and age 73 before 2023, the age is 73. Okay, sorry if we got it wrong. Okay, we're going to correct this slide and send it to everybody. Okay, Brittany? We may have gotten the birth dates wrong. William, I apologize that I'm spending too much time being silly. Let me see here. Okay, Nancy, it would be nice if they kept the gift tax returns. They don't seem to have them anymore, or transcripts. Well, let me tell you, at least now, we live in an electronic age. It's almost impossible to prepare and file a gift tax return without keeping a copy, even if you don't want to. But apparently I'm hearing the IRS does not keep the gift tax returns for a lot of people, or they have lost them. Okay, the final question. Sohail, would you say a bypass trust would get a second step up? Okay, I die, there's a trust funded using my $12,920,000 exemption. Marcia is the lifetime beneficiary, and Brittany is the trust protector. And Marcia gets older, and Brittany says, Marcia, your net worth's pretty small. The credit shelter trust is worth less than the exemption amount. Even you and the exemption amount combined are worth less than the exemption amount. I'm going to give you a power of appointment exercisable in favor of creditors of your estate, but only with the approval of 3 of the people who saw this webinar. They're not beneficiaries, by the way. And then Marcia dies, and there's a step up, because she, even though she's not exercised her power, exercisable in favor of creditors of her estate, there's a nice step up. And in fact, even if Marcia would be subject to estate tax, the power of appointment that Brittany gives her is somewhat complicated. And it says that the power of appointment is only exercisable to the extent that Marcia's gross estate would not exceed $10,000 less than the full estate tax exemption amount. And if it's not over everything over the trust, it's only over the most valuable things in the trust. And the trust might take a $30 million asset, put it in an LLC, and agree to pay $27,000 from that LLC to another entity under the trust. And then maybe Marcia exercises the power of appointment over that. It only uses $3 million of the exemption, and you might get a $30 million step up. I said maybe. Don't hold me to that, but maybe. So that would be a way to get a step up. And that brings up a good point, and I apologize for going so late, but I thank all of you who hung on so long, all three of you, that if I die and I give Marcia my entire portability allowance, so there's a full marital deduction when I die. When she dies, yeah, there's a step up, but there's a estate tax risk. On the other hand, I die, I set up the credit shelter trust. There's maybe no estate tax risk. There's loss of step up risk. But at least you know that you can get some step up by installing a power of appointment. And we are going to court next week for a client to install a power of appointment. There's no trust protector, but we're going to ask the judge if we can install a power of appointment. And based upon past experience, he's going to say, fine, where do I sign? I'm so glad to help this fine family avoid income taxes. Well, speaking of avoid, there is a void in your day. It's time to spend some quality time with your family if they are willing to spend time with you. And it's time for me to page to the very end of this and to hit from the beginning once again, display settings, swap presenter, and thanks again for a wonderful hour and 20 minutes, which only seemed like an hour. Have a great day. Thanks to CPA Academy for allowing us to host on their wonderful platform. Thanks to Lineberg Information Services for letting us write articles and sell our silly products. And thanks to Bloomberg B&A for allowing us to write. Have a fantastic rest of your day and week and year and decade.